Thank you very much, Chairman Leach and Vice Chair Johnson and committee members. I appreciate the opportunity to talk to you all today. Today I'm proposing that the state of Texas add a constitutional amendment protecting the right of parents to raise their children. Over the past 100 years, federal law has outlined specific cases and has given parents the constitutionally protected right to make decisions for their children. But while case law currently protects this right, case law can be fragile and can change. Such a fundamental right deserves to be securely codified, I believe, in the Constitution itself. So the HJR is pretty short. It just constitutionally affirms a parent's inherent right to maintain the care, custody, and control of the children, to make decisions for their upbringing. The amendment prohibits the government from interfering with the parents' rights unless two very specific things. One, it's essential for the compelling government interest, and two, the actions are narrowly tailored to accomplish that need. So the purpose of the bill is essentially to codify what is existing case law as best we know, and I was asked some questions on the floor, which is great. And I think, you know, while in a way it's a simple bill, it's a short bill, I think it's also very important, and it's important that each word is looked at. I am not an attorney. I've spoken to some. We've got testimony. We've met. I've got some comments from Justice Guzman and others in terms of what we think this does. One of the main reasons to do it, frankly, is when you want to defend your parental rights right now, your lawyer has to go to case law. This will make it much more simple. To the best of my knowledge, and again, y'all can ask questions and I'll answer, and we've got people a lot smarter on the law than I am. We are not changing or giving any more rights than currently exist. We are just putting them in the Constitution that makes it easier for parents who need to use them and make it, frankly, much less expensive for parents to use those rights. So with that, I'd be happy to answer any questions that I can, and the ones I can't, I might kick to smarter people than me.
Members, any questions for Chairman Frank? Okay. You've reserved your right to close. Do you have a question? Oh, I'm sorry, Representative Dyson, I didn't see you. Representative Dyson.
Somebody might be tired.
No.
12:30 night.
Yeah.
So it's a question I was asking you on the floor earlier about that is my concern here, and have y'all looked at, are there any current laws or regulations that the state of Texas has in this sector that this constitutional amendment may cause either constitutional challenges to, or just people that will be looking into any changes of those laws?
Well, I don't think so. I think it's a great question. Obviously, CPS and had some discussions with them on the exact words, and it's something that I think really you guys, I don't mean you guys, you should know. These are questions we need to discuss. We believe this is existing law. I believe that any of the, for instance, CPS removals, those would fit both 1 and 2. It's essential for a compelling government interest. We have found the legislature that it's a compelling government interest to remove children in certain circumstances. However, those actions also should be narrowly tailored to accomplish those needs. That's really what is my understanding of existing case law, and I'm certainly not an expert on all case law, but this is making it much clearer, but I don't believe it's expanding it.
Thank you.
Okay, members, other questions? Okay, thank you, Chairman.
All right, thank you, Chairman.
We've got 5 witnesses. I'm going to call a panel of 3 and then a panel of 2. The chair calls Steve Bresnan, Jeremy Newman, and Andrew Brown. And then Ms. Wood and Mr. Covey, you'll be on the next panel. Jeremy, let me start with you. I've got you registered on behalf of yourself and as Vice President of the Family Freedom Project, testifying for HJR 112. Is that correct?
That is correct.
All right.
Yes. Members, my name is Jeremy Newman, Vice President of the Family Freedom Project. Thank you for your time looking at this bill today. The Family Freedom Project does a lot of litigation on parental rights issues and obviously legislative work on parental rights issues. We've worked with Chairman Frank and with Chairman Hughes to draft this during the interim, and with kind of a panel of different legislative experts, judges, district judges. There's a letter being passed around from Justice Guzman, who was really involved in drafting this as well. And similar to what Chairman Frank said, the intent behind the bill is to place into the Texas Constitution rights parents already have, nothing more and nothing less. And we have 100+ years of constitutional case law that outline the rights that parents have. The issues that we are currently dealing with that we're hoping this will help solve are kind of twofold. The first one is that right now that case law is spread through over 100 years, and most of the time, in our experience, the attorneys that families can afford when these types of rights are in jeopardy are not the people who specialize in this area. Those people are expensive. And so you very often end up in situations where both the attorney and even often the judges who are dealing with these cases aren't familiar with the constitutional scope of the right that they're handling. And unless the parents can afford to get to the appellate courts, they often can't vindicate those rights. And so from that perspective, our hope is that it brings some clarity, and you don't have to have someone who's well-versed on the really voluminous case law to be able to vindicate a right that's so clearly stated in the Constitution. The second piece of it is to help ensure the longevity of that right, because right now it's in case law, and everybody knows case law is kind of fragile, right? And you can have new judicial appointments 20, 30 years from now with a different culture and different judges who have different views on the law, and those rights can evolve and change and even go away over time. And so what this bill does is it ensures that the rights parents have as they currently exist in case law are retained for future generations, and it kind of puts a bulwark against the threat that those rights would eventually possibly degrade or even go away completely over time. And Representative Dyson, as to the question that you asked, our perspective is no, that there aren't any laws on the books that are just blatantly unconstitutional that this would change. The expectation is that this would probably almost always be raised in an applied challenge, which is where the law itself is not facially unconstitutional, and the judges actually have to presume the law is constitutional. And an example of that is there was a case at the Texas Supreme Court in December, I believe, where there was a CPS case, and Justice Blackhawk actually mentioned this in his address this year. The O grounds is a way that CPS is allowed to terminate parental rights based on failure to complete services, and it doesn't necessarily have to be tied to a threat of harm to the child, just failure to complete services. And what the court found in that case was not that the law was facially unconstitutional, but that as applied in that case, it would be unconstitutional unless they read it to be really narrow, because basically their opinion was, we can't read this in a way that would allow the state to interfere in the parent-child relationship and sever that relationship if there's not any threat to the child. So we have to read it narrowly to avoid that. So that's the type of situation that it would maybe bring some clarity in, is we're not looking at situations by and large where we have whole statutes that are going to be struck down, because again, these are the same standards that everything's already subject to today. And it's really probably talking almost exclusively about applied challenges where we're making sure that as applied in a very particular case, that we're not applying it unconstitutionally. So with that, I'm happy to answer any questions.
Members, any questions for Mr. Newman? Okay, thanks.
Thank you.
Chair calls Steve Bresnan. Steve, I've got you here on behalf of the Texas Family Law Foundation testifying on HJR 112. Is that correct?
Yes, sir, Mr. Chairman.
All right, go ahead.
Thanks very much. I'm Steve Bresnan here on behalf of Texas Family Law Foundation, sitting with people who I've established friendships with, working on these very issues for a long period of time. We are neutral on the bill for the following reasons. I do think it's well established in Texas law and the United States law that parents have these rights. I don't think there's any disputing about any of that. Our members defend those rights all day, every day in the courts of this state. The neutrality comes from that the rubric here is not exactly the same language. In fact, it's quite different from the same language that's been implied in recent cases where it's a non-parent versus a parent. All the way back to the 1970s with the Amish cases, the Yoder case in particular, the Troxel case in 2000, the Dursap case in 2007, and NRA CJC in 2020. The language of those cases is that a fit parent has these rights. And that there's a presumption that a fit parent has these rights, rather than following what is a quite common description of analysis between being compelling state interest being required and being narrowly tailored. It's very common in the law, but that's not the language in the analysis that's been applied in recent years in the courts. So I'm glad to hear Jeremy make the distinction between facial challenges and as applied challenges, because each one of those cases is an as applied challenge. As I look over the statutes, I think the legislature's done a really good job of making it clear that things should be narrowly tailored. In 153.001 of the Family Code, which deals with conservatorship and child custody, it's clear that courts are supposed to make limited decisions or narrow decisions, and also 153, 193. I won't, unless you ask me to, I won't go back and read those to you. Switching over to the less run-of-the-mill but all too common cases over in the child abuse and neglect area, it's not hard at all to see that the state has a compelling interest in protecting children from abuse and neglect. So in the parent versus non-parent category, that most recently has been what's been established in the by the courts of this state, and by non-parent I would include CPS obviously in that as well. In the parent versus parent situation, it becomes a little bit dicier because someone's got to have the child on certain days of the week and for certain hours. And I suppose you could come up with an extreme case where someone was so deprived in the absence of any evidence of the time they ought to have with the child that could meet one of these constitutional challenges. But there's all kinds of remedies in the Family Code for that now. All of that said, I want to be clear that an action of a court is state action. When it's private litigation, it's still state action because courts are making decisions. All of that said, as I look out over the Family Code, I don't find things that are objectionable on their face. I do think that there is a San Antonio Court of Appeals that applies this kind of analysis. Justice Thomas in the Troxel case, which was a plurality decision that seems to be governing most of the law in this area, advocated for this same kind of analysis, and the plurality rejected that. But as we sit here, I've not had any of our members, and I don't see from my experience in working with y'all on these bills that Texas Family Code has obvious gaps in it that would be negated or that would be vulnerable, for example, under this rubric. So I'll be happy to answer any questions.
Vice Chair Johnson.
I just want to pick up on where you said the interest of the parent versus another entity or organization versus a child. And I don't think this is at all Chairman Frank's intent, and I'm just asking out of curiosity. Having done juvenile justice issues, I have seen parents that almost treat their child like chattel or property. If we have a situation where we have legal protections where the child has a right to counsel, the child has the right to meet with counsel by themselves, and you have a parent that says, no, that's my kid, you can't do any of that, and effectively the parent feels like they have the ability to interfere with anything on the child's behalf. Do you think this constitutional amendment would, in essence, give a parent the power to intervene in that circumstance and give them a greater right to influence the child? Does that make sense?
No, I understand exactly what you're asking. To me, this has the issue, the first analysis is there a compelling state interest in the state of providing the child with counsel in a way that might be adverse to the parent's wishes? I personally can conjure up circumstances that there would be a compelling state interest in doing that, particularly the more that line gets over towards abuse and neglect, where in a way it's a conflict of interest for the parent in some of those circumstances. Then to narrowly tailor it, the right to counsel is a right that's enjoyed by human beings in most contexts. I could see how it could get out of bounds. I could see how people could use this arguments to contest that in a given case, but I think they could do that now as well. In that sense, I think this language is not frightening to me in that regard.
Thank you very much.
Thank you, Vice Chair. Yes, Representative Blowhood.
Thank you, Chairman. Mr. Bresnan, how would this constitutional amendment affect, let me read it, competing parenting decisions for the upbringing of the child? So, I mean, I guess my question, if any, and it may not, if both parents have an inherent constitutional right and they differ on their upbringing, like, would there be any effect on that? How does that work?
I think if we apply the analysis, the state has a compelling interest in making sure that kids have safe, stable homes where they get fed and they're supported and, all those kind of things that are in the interest of the child. In the family code, as you well know, the general test is best interest.
Yeah, I was going to ask.
Just before last interim, in the case of NRA CJC, there was a gap in the family code on modification cases. Texas Supreme Court read into that a constitutional fit parent presumption as part of the best interest analysis in those cases. So the courts filled in that gap where there was arguably a gap in the legislature, in the statute. There was a presumption, fit parent presumption over in the general custody statute, but it wasn't in a modification statute, and the court read that into, that's the bottom line from NRA CJC. Again, that was a parent versus non-parent. So I guess we could conjure up an extreme case where I don't think compelling state interest is a concern. Whether the remedy fashioned by the court in a given case was narrowly tailored to achieve that interest, I suppose would be fair game for lawyers to question. If someone was so deprived of a right without the evidentiary basis to stretch that, then I suppose our lawyers are going to make arguments in that regard. Again, I think they can do that today.
And I think it's safe to say that if parents disagree on parenting, that's still, I mean, that doesn't get affected. All we're doing is codifying the parents and strengthening their rights as parents. Interfamilial disagreements, I'm not talking about abuse, just parenting decisions, that's not affected by it. I mean, that still would be handled if it had to through the court system in of itself, right? Because this doesn't
Yes.
affect BIC.
I think, as lawyers will, we could come up with a hypothetical that would stretch the bounds
Allegedly.
of it. But I think in your garden variety everyday case, where we're deciding whether somebody gets the standard possession order or the expanded standard possession order, that courts will give other courts leeway to make those decisions in a way that meets the best interest of the child. So I'm not, I don't practice family law. I practice with y'all, whatever law I'm practicing, I'm doing right now. But we have represented family lawyers for about 15 years or so, maybe more now. And we have not, from our membership, had people filter up to us a great deal of concerns. We ask those kind of questions, and I think they're fairly comfortable that what it may change. I think early on it may very well change the arguments that people will make, but I think lawyers will be responsible in doing that. Swinging for the fences costs money, and a lot of people don't have that money to swing for the fences, as Jeremy pointed out.
Thank you.
Yes, sir.
Can I add something on your last question?
Yes, sir. Oh, sorry.
Yeah, actually, yes, go ahead, and then I want to get to Mr. Brown.
I was just going to let you know, there's actually a body of federal case law on that exact question of what do you do when you have two fit parents who are in a dispute like that. And the way the federal courts have handled that is they said essentially, look, these are two equal rights. They effectively cancel each other out, and the way you determine is you use the best interest of the child standard, which is Steve's point, right? But the way they conceptualize that is you have two equal rights in dispute, and so they effectively cancel each other out.
Thank you. That was my concern. Perfect. Thanks.
All right.